This week, a new Colorado Supreme Court ruling says ski resorts can no longer use waivers to shield themselves from lawsuits. This stems from a case dating back 2 years ago when a teenager was paralyzed after falling from a ski lift.
The family sued, saying that the ski area should have done more to protect her. But the claim was dismissed in district court. This week, the state Supreme Court overturned that, allowing the family to continue their negligence claim.
So let's talk about this ruling. That's why we have our 9 News legal analyst Whitney Traylor joining us now. So let's talk about the path that this case had to take to get to the Supreme Court. What merited it going to the high court of the state?
Well, it's very tragic facts. As we know, the young girl, she was 16 at the time in 2022, got on the ski lift, wasn't properly on, her and her dad. Her dad was trying to help her. They got about 30 feet up and she fell on her back and now is quadriplegic. And so the issue was everybody was screaming to shut off the chairlift, and there was nobody operating it. There was no one there. So she suffered these injuries, and the ski resort relied on the various exculpatory clauses that they had online. So when he went to buy it through his Epic Pass, it said you assume the risk, there's a limitation of liability, all these things. And essentially the ski resort said, hey, you signed this saying we're not liable regardless. And that's how the lower court ruled. So then they appealed it to the Supreme Court, and now the Supreme Court, the short version is the Supreme Court's essentially reversed that, but it's much more technical than that. Yeah, and I'll try and keep it as broad as I can. But that's where we're at now.
I mean, this case was egregious. I mean, she was hanging from the lift. It was just awful.
Yeah.
But what does that say about these waivers? Most of us don't really read them.
That's correct. Most of us don't read them. And in this case, it was on the Epic Pass, and he had to, there were very broad-based waivers that were, there was an assumption of risk, an exculpatory clause, and a limitation of liability saying, hey, you know this is a dangerous sport. We're not going to be liable regardless of what happens.
And every ski area does this.
Every ski area. I mean, when we go and park our cars, a lot of times it'll say not responsible for lost or stolen articles in your car. It used to be printed on the ski ticket when you go to a baseball game, a hockey game. These type of exculpatory clauses are on the ticket.
From a legal standpoint, there's a presumption there that you've accepted it. You don't always have to check a box.
Yeah.
So what if you say, like, I buy my ticket, I go to the hockey game, the baseball game, I go skiing, and I say, no, I don't accept this. You can't go in, you're out?
Essentially, it's saying by accepting this ticket, by using it as entry, you are agreeing to these terms. But that is the argument. We don't have, first of all, we're not going to read all this fine print. We don't really understand it. We're not, you know, this isn't a negotiated agreement. But what's interesting is the ski resorts, this limitation of liability has been forever. This is the first time that the courts are saying, hey, you may have liability. And it doesn't mean that there's actually going to be liability. It just means it's going back to the lower court for them to continue. In other words, the claim is still alive. It was dismissed initially, and now it's still alive. It doesn't mean it'll ultimately get to trial and ultimately be successful.
And that's kind of the important thing.
Yeah.
And so you got to think every ski area is thinking about this. I mean, skiing, we report on, sadly, a lot of deaths and a lot of accidents involving skiing.
Correct. And what's unique about this is that they said, look, this waiver doesn't necessarily apply when it's a negligence per se claim, as opposed to negligence of the highest standard of care. And negligence per se is when it's public policy. So we have a statute, the Ski Safety Act, that says these certain actions are prohibited. So what's still, the ski slopes, ski resorts probably can waive liability for things inherently dangerous. So going down the hill fast, even falling off the chairlift may be something that is waivable. But here it was because the operator wasn't there. So there was some operator negligence. So it's unique in that regard.
The important thing now is from this case is what we have is this ruling. The next step is really what we have to follow with that particular case. Correct.
So the next step with this case specifically, what's going to happen, it'll go back down. I think it's a case in Broomfield, so it'll go through presumably trial or settle, and then it could be appealed again. But this is how our common law is shaped. So now we have this one Supreme Court ruling, so now how will it be applied to other situations, other inherently, you know, somebody's at a hockey game, gets hit in the head with a puck, will this then apply? And so that's how our system evolves. The courts interpret these statutes, and then it evolves with each case as the facts differ. But this is incredibly significant, and to your point, Kim, there were a number of different entities that filed amicus briefs, essentially friends of the court, where they said, we want to weigh in too. So the ski industry, a number of youth sports played in, because they said, look, if we have this level of exposure, we're going to have to either raise prices or shut down. Yeah, essentially.
That's the most. There's a lot to cover. We'll continue to do it. Whitney, it's always good to catch up with you. Thank you.
Yep, thanks.